Okay, hello and welcome to the video for the first class of this intellectual property course. I'm your professor, Brian L. Fry, and in each of our classes, I'll be preparing one of these videos in advance. In general, what I'm going to be doing is just providing some background information about the legal concepts and doctrines we're going to be discussing in the class, as well as background facts and concepts expressed in the cases that I ask you to read for the class, by way of ensuring everyone's on the same page and we're all prepared to engage in discussion in class. In this video, it's going to be a little bit different because it's the first video for the class. What I'm going to do instead is walk you through a few basic class procedures and principles, as well as how the class is going to be put together. And then also kind of provide a really a brief initial introduction to the concept of intellectual property and the various forms of intellectual property we're going to be talking about in this class during the course of the semester, as well as sort of general theories of justification for intellectual property, which we'll be returning to throughout the course of the semester. So let's begin by talking about the class materials. What are you going to need for the class? Well, the casebook for the class is published by Semaphore Press. It's by Lauren and Miller, and it's titled Intellectual Property Law Cases and Materials, version 7. So make sure you get the most recent version. It's available as a PDF download on the Semaphore Press website. You can also order a hardback version if you so prefer, and there's various ways in which you can obtain the hardback version. Before reading the casebook or before buying the casebook, I hope you'll take a look at the syllabus, in which I describe what the casebook is and provide a statement from the authors of the casebook, specifically asking you to satisfy their pay what you wish requirement request of $30. And once you have obtained the casebook, please fill out the 2-question casebook survey that is on the Canvas page for the class. It shouldn't take you more than 20 or 30 seconds to fill out. And I'll use that as an opportunity to tell you to make sure that you're signed up for Canvas as well, and that you monitor the Canvas page, because Canvas is where I'm going to be putting the course materials for this class. So make sure you use Canvas and that you're signed up for Canvas. Okay, like I said, I'm going to be recording a short video for each class. Hopefully I'll be getting a little bit further ahead of the game as things go on. I apologize for recording these first 2 videos so proximate to the actual course session. I'm going to try to get a little bit further ahead, but they're all going to be brief, and you shouldn't have any trouble watching them prior to class, especially because it's going to be an afternoon class meeting. So please do make the effort to watch through the video prior to class, even if you aren't able to make it all the way through the readings, right? So part of the idea behind the videos is that they'll provide you with enough information about the course materials that even though it's not ideal, at least you'll be able to follow along and understand what's going on in class and hopefully participate in class discussions, even if you haven't managed to make it all the way through or fully process the readings assigned for the class session in question. In addition, I'm going to try to circulate questions for discussion, maybe not for every class, but at least sometimes I'll be providing questions and observations prior to class, and I encourage you to reflect on those before class, because we'll return to them during the course class session. And the more you think about them in advance, the more you'll have to add to the conversation. We are going to have, of course, discussion meetings, I prefer to call them now. So we'll have primarily in-class sessions twice a week. And then we'll also have a 3rd session, which will be on Zoom. Part of the idea behind this is to satisfy the ABA requirements for an in-person class, as long as we're 2/3 in person, then the class counts as in person. It's also, of course, really nice to have in-person classes, COVID permitting. So hopefully nothing changes over the course of the semester. But I do think that Zoom classes can be helpful and interesting as well. And ideally, we'll also be able to incorporate class visitors as a function of having Zoom class meetings. So I'll keep you posted on that. In general, Mondays and Tuesdays will be in person and Wednesdays will be Zoom meetings, except in cases where we don't have Monday classes, in which we'll just have 2 in-person classes on Tuesday and Wednesday. And in addition, I will occasionally post written assignments to the Canvas page as well. Those are non-graded, but I hope you will complete them. They're intended for your benefit. They will provide an opportunity to briefly reflect on course materials in a hands-on, practical kind of way, typically in relation to real-world problems that have recently cropped up and that I'm interested in having us reflect on collectively in class. And in addition, the written assignments that I provide will be a window perhaps into what the examination for the class is going to look like. So I'll get to that in a moment. Specifically, your grade is, of course, as in most of your other law school classes, going to be based on the final exam for the class. And hate to say it, but I'm going to be curving the grades for the class per the required average grade of the College of Law. I don't have a choice about that. So it's just the way that it is. I will say that the exam is a little unusual, a little different, at least, than the exam in some of your classes. It will consist of 3 take-home research memos, each of which will have a 1,000-word limit. And your research and your memoranda will be based on an open universe set of materials. In other words, you can use anything you want to. That means Lexis, Westlaw, the casebook, law review articles, anything that you think would be helpful in answering the question, you should feel free to take advantage of it, because of course, that's how it'll be when you're actually an attorney and a senior attorney or a judge asks you to prepare a memorandum of law on their behalf, right? They won't hand you a closed universe of material to look at. They'll say, go out there and find me the answer. I don't know where it is, but I'm relying on you to help me figure out how to answer this question. And because I want this to be realistic, when you answer your exam questions, you're also permitted to talk to anyone you want to about those questions, right? That means you can talk to each other. You could work through the exam questions collectively. You can talk to third parties, anyone you want to, anywhere you think you can get information that will be relevant to providing a better and more useful exam memorandum is absolutely fine with me. And in fact, I encourage you to do that, right? That's a process that I call learning. And the point of the class is to help you learn as much as possible about intellectual property and the concepts surrounding and informing intellectual property so that you'll be better able to apply those ideas when you become an attorney and you're confronted with these kinds of problems in the real world. So you'll have plenty of time to complete these 3 memoranda. I usually give students about 3 weeks. I try to prepare the exam as far in advance as possible and give everyone as much time as I possibly can give them to work on it. Oftentimes, I'm even able to get the exam out prior to this Thanksgiving break, which really gives you a nice span of time in which to think about, reflect on, research, and put together your research memo. It's not only an opportunity to think about intellectual property law, it's also an opportunity to practice your legal research and writing skills, which I think is really important and something that law students don't get nearly enough of an opportunity to do, especially in their 2nd and 3rd years of law school. The exam will be due at 5 p.m. on the last day of the finals period. And by that, I mean, it will be due on the last day of the finals period as explained in the academic calendar, which means typically it's on a Saturday, right? So turn in your exam by 5 p.m. on Saturday. If it's a little later, whatever, it doesn't really matter. It's sort of a loose deadline. The idea is that's the last day of finals period. Every semester I get people asking me, oh, what's the last day, blah, blah, blah. Well, A, it doesn't really matter because I don't care. But B, it's Saturday, just like it says on the school website. Okay, it's Saturday night, whatever. Okay. Anyway, we'll talk about the exam more later in the semester, but just a brief intro. And if you're interested in what prior exams look like, I have posted all of the exams in this format that I've ever given in my intellectual property class on the class Canvas page. So you can not only see the old exams, but you can also see kind of example answers that were provided by students in previous years. And those were all examples that I thought were especially good. I thought it'd be more helpful to share really good exam answers than not so good exam answers. So do go ahead and check those out. They'll give you a feel of what my expectations are and hopefully be inspirational for you as you think about what your own exam answers are going to be looking like and sort of how participating in and thinking about the materials we're discussing in class will help you when you find yourself at the end of the semester trying to think creatively about how to answer these really difficult questions. Because the reality is that in the real world, these are always really difficult questions, and I wouldn't be giving them to you if I didn't think they were hard. Right? So this is really the kind of the background idea here, is to get you thinking critically about concepts in intellectual property and how to explain them to the relevant people who are going to have to be applying these concepts in practice in the real world to resolve real world disputes between real world parties. Okay, so what is intellectual property? Anyway, when we talk about intellectual property, what are we talking about? Here you see a Girl Scouts badge for the intellectual property merit badge. I kind of love it, right? It's like, let's get them started young, thinking about how to be landlords, as I like to call it, or intellectual landlords, as it were. But let's think about this for a second. What are we talking about when we talk about intellectual property? We all kind of take it for granted, right? These days, it's sort of like, we're in the 21st century. Intellectual property is the new form of property. It's like where all the value is in different kinds of businesses. Everyone's really interested in patents and copyrights and trademarks and trade secrets and so on and so forth. And, you go out to pitch your company to investors and like you're looking for a hedge fund to invest money in your startup. And you talk about your intellectual property portfolio and all the patents you got and the trademarks you registered and the copyrights that you own, et cetera, et cetera, et cetera. What are you talking about? What's the relationship between all of these different forms of exclusive rights that are cabined within this kind of umbrella that we call intellectual property? Well, a lot of people think, and not without justification, that all of these different things that we talk about as being intellectual property actually don't have anything to do with each other at all. And there's a lot of truth to that, right? So in this class, we're going to be talking primarily about trade secrets, patents, copyrights, and trademarks. And the reality is we call all of those things intellectual property, but they're fundamentally really different, right? They go to totally different kinds of subject matter. They employ totally different, fundamentally different doctrinal principles in determining what the law actually can and does accomplish, and the kind of purposes and justification of all those different kinds of intellectual property have nothing to do with each other, right? So there's a huge fundamental disconnect between all these different areas of law, but for some reason we've decided to lump them together under one heading. Why have we done that? Well, a lot of people think we shouldn't. I do think that one potential advantage of doing so is that it does encourage us to think about the kind of very abstract, high-level features that they do have in common, specifically that all of these different forms of property or exclusive rights or monopoly privileges or whatever you want to call them, right, do go to kind of intangible goods, or as a lot of people refer to them as knowledge goods, right? They go to ideas, they go to concepts, they go to expressions, they go to the exclusive right to use or sell or transfer or in other ways take advantage of, right? Something abstract, something intangible, as opposed to the kind of scarce, tangible stuff that we think of as physical property in the traditional sense. Okay, so lots of different kinds of intellectual property going to all kinds of different subject matter. I kind of lay out those different kinds now in a kind of taxonomy, right? So some go to information, like the tort of misappropriation, which we'll be talking about in our next class, misappropriation of otherwise unprotectable material, and trade secrets, which are like the tort of misappropriation, but goes to confidential information, right? So trade secrets have to be confidential in order to be protected. And part of what's protected is, in fact, that confidence between the parties in question, right? Then we have intellectual property that goes to ideas, right? We might think of those in terms of utility patents, design patents, plant patents, different kinds of exclusive rights that fall within the scope of ideas, right? And then we've also got intellectual property that goes to expressions, the kind of the paradigmatic form of expressive intellectual property, right, is a copyright, which goes to works of authorship as opposed to inventions and discoveries or original designs when it comes to design patents. We've also got other forms of kind of sui generis, as it were, intellectual property rights that on one level seem to fall within the scope of expressions insofar as they're within the title of the US code that includes the Copyright Act, but other ways actually kind of look more like kind of idea rights, right? So vessel hull designs, right? Rights in the shape of the vessel of a boat, and mask works, which are the designs of different kinds of semiconductors, right? Are those expressive? Well, not in the traditional sense. They fall within the scope of the same statutory provisions as copyright, but in a lot of ways, they look a lot more like patent rights because they go to things that do something as opposed to something that express something. And then finally, we've got exclusive rights that go to commercial goodwill. Kind of paradigmatic form of those is the trademark or distinctive mark that communicates information about the source of a good to consumers. In other words, trademarks identify products and services to consumers in such a way that consumers get more information more efficiently about those goods and services, and thereby benefit consumers in that way. We also have a similar set of state law rights called rights of publicity, which are sort of like trademarks in celebrity, although not entirely like that. And effectively what rights of publicity do is go to protect exclusive rights in celebrity goodwill, the value of being a celebrity and all the positive feelings that people have about celebrities that ultimately result in commercial value that is then granted exclusively to the celebrity who controls that name or likeness. Okay, well, where do intellectual property rights come from? The kind of core constitutional provision authorizing Congress to grant intellectual property rights in the first place is the Intellectual Property Clause in Section 1. And I really like to point out, right, that this is a contingent right, right? The Constitution gives Congress the power to create certain kinds of intellectual property rights, essentially copyrights and patents, but doesn't require Congress to create copyrights and patents. It says, essentially copyrights and patents might advance science and the arts, and to the extent that you, Congress, think that they will, you should go ahead and create these exclusive rights in writings and discoveries and works of authorship and inventions and discoveries in order to achieve this goal. You don't have to do it, but if you think it's a good idea, go ahead and do it. Well, unsurprisingly, Congress took the suggestion very early on, and in 1790 created both patents and copyrights, and we've had them ever since. And we'll talk more about what the Intellectual Property Clause does or could mean and how it might inform the way we think about intellectual property protection, specifically in relation to patents and copyrights. But that's not the only source of intellectual property protection on the federal or on the state level, right? So of course, we've also got the Commerce Clause as a basis for intellectual property protection. And the fact that it can work in that way really illustrates the extent to which, at least on one reading, intellectual property rights really are commercial rights, kind of writ large. Intellectual property rights are really about the commercial value of whatever intangibles it is that they happen to be protecting. And because the Intellectual Property Clause only goes to the kinds of rights encompassed by patent and copyright. When Congress wanted to create trademark protections, the Supreme Court actually said, no, you can't do that under the intellectual property clause. It doesn't give you that power, but there's a saving clause, right? The Commerce Clause, which, as we all know, essentially these days says Congress can do basically whatever it wants to when it comes to regulating commerce. Well, among whatever Congress wants to do, regulating commerce is regulating the use of descriptive marks on a national basis, right? So Congress used its Commerce Clause authority to create federal trademark law and it kind of placed that power within the United States Patent and Trademark Office, which, among other things, federally registers trademarks, which are then used by businesses across the country and around the world. Okay, so a second basis for Congress's exercise of its authority to create intellectual property rights or to create rights in intangible knowledge goods. Of course, states can do the same, and they do the same, and they can do that under their broad police power, right? There's no particular clause to look to for that, but we all know that states can exercise a police power to regulate affairs within and in some cases without the state, and states have used that power to create parallel regimes of trade secret law, parallel regimes of trademark law, and their own regimes of rights of publicity, right? So different kinds of intellectual property rights that we'll be talking about in the course of the semester are subject to either state or federal law or both, right? And sometimes federal law is actually preemptive of state law, as it is entirely in the case of patent law and almost, if not entirely, in the case of copyright law, but not preemptive in other contexts, like as respect to trademark law and trade secret law, which still have varying degrees of state involvement in the promulgation and enforcement of those kinds of rights. Okay, so what are we trying to accomplish? Why do we have this in the first place? Well, the positive story about intellectual property is that it's a huge revenue generator, right? It's a huge way of, creating and maintaining value that, especially in information economy, unsurprisingly, information goods are really valuable, and having property rights in information goods is really a positive thing. And we can see all the jobs and all the business and all the money that comes to the United States through creating and managing intellectual property, et cetera, right? Essentially, the idea is we create private rights in different kinds of things because private rights facilitate the negotiation between different individuals over those exclusive rights. And as you know, every one of you who's taking property or other kinds of business law classes will know, Coase said that, in the absence of transactions costs, the market will always ensure that goods go to their best and highest use. And why should information goods be any different, right? We create property interests in information goods. That just means that the person who values them the most is going to end up owning them. That's great. We shouldn't be worried about it. It's a wonderful thing. Well, of course, there's a couple problems with that, right? One is that Coase wasn't saying what a lot of people think. He was saying, in fact, his point was that there's always transactions costs, and the real problem isn't ensuring that there's a market, it's ensuring that we minimize transactions costs to the best that we can, because the ubiquity of transactions costs means that things never actually always go to the best and highest use. And we just want to make sure that happens as frequently as possible. But there's another problem here, right? Which is that information goods are different from other kinds of goods insofar as they're not scarce, right? Most kinds of goods only can be owned by one person, and if one person owns it or uses it, then other people can't own and use it. Information goods are totally different, right? Ideas, expressions, they're what we call non-rivals. Many people can own and use them as want to, and the supply never goes down, right? If I have an apple, I eat the apple, there's no more apple anymore. If I have a wallet, you take my wallet, you have the wallet, I don't have the wallet anymore. But with ideas, if I have the idea, I tell you about the idea, then we both have the idea, and there's just as much idea left for everyone. So it's not as clear that property rights are necessarily the best way to go about maximizing the value, this net social value of the goods in question. And a lot of people are concerned about that, right? So there's an entire open source, open access community, a whole kind of movement toward freedom of ideas and the concept that information wants to be free, which points to the fact that historically intellectual property rights were much more limited. And it's only as information became more valuable that people became more grasping in relation to information. And really what they were looking to do was extract value from consumers and from society, not necessarily to maximize that value for everyone. So the real question is, how do we look at intellectual property rights as they work in the real world, right? Are they value maximizing, right? Do they make it more efficient for us to produce and exchange and, utilize the kinds of information goods that they protect? Or are they purely extractive? Are they a kind of monopoly right that people use to pull value out of society and take for themselves? In other words, are they multiplying or are they zero sum? Or maybe it depends on the circumstances. It's hard to say. Maybe it's not always one answer. Maybe it's lots of different answers. And maybe we'll spend some time kind of wrestling with that question over the course of the semester. But I wanted to kind of leave you with two kind of big picture ways of thinking about intellectual, we call them theories of intellectual property. What we really mean is theories of justification of intellectual property. And what's important here is not just what those theories postulate, but also what they imply, right? So consequentialist or utilitarian theories of intellectual property argue, in effect, that we have to have a special justification for intellectual property rights, distinct from other kinds of property rights, because intellectual property rights are fundamentally different. And so the idea here is that any kind of rights in property is justified only in relation to its consequences, right? So if it produces good consequences to create a certain kinds of rights, then those rights are justified. If it produces bad consequences, then those rights aren't justified. Well, what's unique about intellectual property rights? As I said previously, they're different from other kinds of information goods, are different from other kinds of goods because they're what we call non-rival and non-excludable, right? In other words, they're fundamentally public goods, what we call public goods. What's a public good? It's a good that doesn't decrease in supply as it's consumed. So most goods are scarce. When you use them, there's less of them there left for everyone else. And so the primary concern is conserving the good to make sure that it's used effectively and efficiently and isn't wasted on bad uses. Well, we don't have to worry about that when it comes to information goods, because information goods aren't depleted, right? When you use them, there's still just as much there as there was before. The problem, the scarcity issue, such as it is when it comes to information goods, is a dynamic, not a static, fancy way of saying, right? It's not a problem of conserving goods that already exist. It's a problem of ensuring that those goods that don't yet exist are actually created, right? So when it comes to public goods, the key concern we have is known as the free rider problem. This is the idea that because these goods are non-rival and non-excludable, in other words, they don't diminish when they're consumed and no one can stop you from consuming them, that people will consume without paying the cost of production, right? In other words, if I can use it for free and I don't have to pay for it, then I'm not going to. I'm just going to use it for free and not pay for it, right? This is kind of consistent with this whole idea of home taping is killing music or the internet is killing music. It's music's still alive, but there was this concern that, well, if people can use it for free and then they're not going to pay for it, and therefore we're not going to have anyone to produce it. In other words, no one's going to make stuff. No rational producer is going to continue producing information goods if they know that they can't force people to pay for them, right? So what do? We create exclusive rights that say, you producer of this information good under the right circumstances will have exclusive rights to use and permit others to use it. Therefore, you can charge people. We're going to make it excludable for you so that you can charge people, and we thereby solve the problem, right? All of a sudden, no more free rider problem because the producer of the good can now compel potential users to pay the cost of production and maybe even generate a profit. So the justification for intellectual property rights then is that they solve market and government failures in public goods because private parties know what consumers want. We want to encourage private parties to make those information goods that consumers want, and intellectual property rights are going to do it. Now, there's an implication here that if intellectual property rights are justified because they solve market and government failures in these public good information goods, then they're only justified to the extent that they solve those market and government failures. And when they don't, right, when they don't work, then it also follows that they're not justified. So on some level, the consequentialist kind of argument in favor of intellectual property is a really compelling one. It's a kind of, it's an incentive-based argument that kind of draws on neoclassical economic theory and makes a lot of intuitive sense. The problem is it also provides a kind of built-in critique, right? It says when intellectual property rights work to accomplish this goal, then they're justified. But when intellectual property rights don't work to accomplish this goal, then they're not justified. And it also implies that maybe we ought to be spending some time asking ourselves when and why do intellectual property rights work and when and why don't they work? Okay, well, there's a second justification for intellectual property rights. These, or rather, second group of justifications. These are usually placed under the category of non-consequentialist or deontological moral rights. Essentially, what they say is, we don't need any of this consequential stuff, right? We don't have to point to good consequences. Intellectual property rights are justified just because they are, right? In other words, people are entitled to exclusive rights in the expressions, the ideas, the distinctive marks, whatever that they generate, just because it's the right thing to do for whatever reason, right? So on one kind of Lockean natural rights theory, right, we say that, look, these things wouldn't exist if the people didn't discover or author or invest the time and energy in producing them. Therefore, there's a natural right to own what you're responsible for creating, right? You mix your labor with the world and you're entitled to what results. You're entitled to own what results, irrespective of what the consequences are. It would be unjust not to let you claim ownership of that which you've created. An alternative, kind of more Kantian or Hegelian way of looking at the question is to say that it's part of kind of self-actualization and self-realization for people to be able to exert control over the expressions of their personality, whether that's expressions through the form of literary or other kind of creative expression, or expression in the form of inventions or whatever, right? It's a way of respecting the autonomy of individuals to allow them to exert certain forms of control. And therefore, we don't have to look at the consequences of granting those kinds of rights. We can look just to the fact that it's appropriate and justified to grant those rights in the first place. Well, a lot of people say, well, why not both, right? Can't we be, consequentialists here and deontologists there? And why not a little bit of this, a little bit of that, right? Like, let's have all these two great tastes that go great together, as it were. The unfortunate thing is that they often conflict with each other, right? In other words, what do you do when a consequentialist theory says this particular set of rights is not justified because it produces bad outcomes, and the deontological theory says, no, it is justified because it's consistent with human flourishing and autonomy, right? One says no, the other says yes. You kind of can't have both at the same time, and you have to ask, which value is going to win out. Let's talk about that in class.